Hey everyone, welcome back. Today I have two amazing attorneys with me from Kantor and Kantor, Glenn Andrew and Andrew Kantor. And they are attorneys that specialize in a few things, but one being ERISA law, and that is the Employee Retirement Income Security Act of 1974. We will explain this. This conversation is all about long-term disability, disability benefits, fighting for your rights with an insurance company. And these guys are the ones that go to bat for you. So you've already heard my personal story in the intro about my disability story and having to fight an insurance company for 20 years. And I don't want people to have to do that. And a lot of people don't have the wherewithal, the knowledge, or just again, the emotional fortitude to deal with it because it's tough. So welcome to the show.
Thank you so much. Happy to be here.
Yep.
So let's just talk a little bit about when you work for a company, sometimes they offer these amazing benefits, right? They offer health insurance and sometimes they offer disability and you could, and I want to make it clear that you don't have to get injured on the job. You could get hit by a bus on a Saturday and still, if your hands don't work or you're amputated or some awful thing happens and you can't go back to work, then you would apply for long-term disability policy through your company. And then some people buy it on their own. And so what I'd like you to share right now is the difference between a policy explain ERISA, but the difference between a policy bought on my own through a company and I'm just an individual buying a long-term disability policy versus someone who gets it through an employer.
Okay. I'm happy to do that. It's a little complicated, but somewhere around 60 years ago, the company that made the automobile Studebaker went bankrupt. And it had a pension plan for its employees, and that pension plan should have survived its bankruptcy. The problem was Studebaker had invested almost all the money in the pension plan in its own stock. So when Studebaker went bankrupt, its stock became worthless and the pension plan became worthless. And Congress decided we're not letting that happen. In 1974, a law was passed. As you said, it's ERISA. It's the Employee Retirement Security Act of 1974. And the intent when it was passed was to make sure that pensions would always be solvent. So as people retired, their pensions were protected. About 15 years after it was passed, the U.S. Supreme Court decided that ERISA not only governed pensions, it also governed other employee benefits, primarily health insurance, life insurance, disability insurance. Now, it covers people who get their benefits through their employer unless their employer is a governmental entity or a church group. And when we can talk about that, the vast, vast majority of people who get their coverages are covered by ERISA. And what that means to people, ERISA provides certain, what we call remedies, in the event that you have coverage, you become disabled, you make a claim, and for some reason the insurance company denies it. Under California law, and that's where I practice, so I'm most familiar with it, if you were to go out and buy a policy separate from your employer on your own, it is then not an employee benefit and it's not governed by ERISA. So let's kind of start with what happens if your coverage is not governed by ERISA, but governed by California law. If an insurance company denies a disability claim and it's not under ERISA, and it's deemed that that claim denial was unreasonable or reckless, then the insured can sue for not only the insured's disability benefits, but for emotional pain and suffering, for attorney's fees, for other economic losses. And if the court determines the denial was really bad and was in reckless disregard of the insured's rights, a jury can award punitive damages against the insurance company. And punitive damages are there to punish the insurance company so it doesn't do the same thing to other insureds, to teach them a lesson. Now, let's get back to ERISA. If you have your coverage through ERISA and the claim is denied, your remedies down the road if you end up in court are that you get your benefits owed potentially up to the date that the court decides they're owed. potentially, not always, but potentially interest on the unpaid benefits and potentially attorney's fees for the work your attorney did in litigation. So the remedies available to an insured who has their coverage governed by ERISA are far, far less, at least in California, than the individual who purchases their coverage separately. Now, I will say that there are states that don't offer these bad faith remedies, that you're limited to breach of contract. And honestly, sometimes uh, insureds are better off having ERISA coverage because they can at least get their attorney's fees paid if they have to file suit. There are numerous other problems with ERISA. Uh, the courts decided long ago that due to the nature of ERISA, there's no right to a jury trial. It's decided by a judge. There is no right to have witnesses testify at the trial. The judge will look at what we call a cold record. It's the file put together by the insurance company, and the insured gets to assist in that by submitting medical records and other kind of records. And the judge looks at that record, reads the briefs the lawyer submits, sometimes holds oral argument and lets the attorneys argue. Other times just reads the briefs, looks at the record, and decides who wins. So, having a jury is a really nice thing, but it's not there under ERISA.
One point I want to make really quickly. So, I want to kind of highlight really quickly why the contrast between ERISA and a non-ERISA policy ends up being important to people who actually file disability claims. So, as Glenn pointed out, if you only thing you can get if they wrongfully deny your claim is the money you're owed. In contrast, in many states, if they wrongfully deny your claim and your claim is not governed by ERISA, you could get what you're owed and far more than that. You could get potentially millions of dollars for them wrongfully denying your claim. Now, why does this matter to most people? Frankly, most people don't care that, oh, if I sue them, I don't get punitive damages. Most people don't care about getting $10 million on top of their claim. They just want to get their claim paid properly, and they want it to be paid fairly. So why does it matter whether it's ERISA or non-ERISA? The reality is, insurance companies, when they look at claims, they don't look at just your claim. They first look at claims from a 30,000-foot perspective. They look at what the cost benefit analysis is, how much it costs them to pay claims, and how many they can reliably deny while still making money. And so when they have to make this assessment, when they look at non-ERISA claims and claims in California, they look at the cost to deny a claim. Well, we could end up owing what we already owe and a lot more. The cost to deny an ERISA claim is just what they owe anyways. What this creates for ERISA insurers, especially compared to insurers who are not governed by ERISA in places like California, is a massive incentive to deny claims because as Glenn has told me a million times, the best analogy is what would our society be like if the only punishment for robbing a bank was, if caught, you had to repay what you stole potentially with interest? I mean, people would be blowing off safe doors everywhere, right? Because there's no incentive not to try to rob the bank, because if you don't get caught, you get away with all the money, and the worst that happens if you get caught is that you have to pay it back. And you multiply this by tens of thousands of claims, and ERISA insurers see claims and they just do not fear wrongful denials because there's no financial incentive for them to fear them. And, I've been doing this for about 10 years. Glenn's been doing it a lot longer, but I've had several opportunities to observe the same insurance company assessing an ERISA claim and a non-ERISA claim, either at the same time or with the same person around different times or both. It's striking the things they do differently in a non-ERISA claim versus an ERISA claim. One quick example that just came up, in an ERISA claim, what they'll love to do is they'll surveil you, not tell you they've surveilled you, and then interview you in the hopes that they catch you undermining the surveillance somehow, or basically catch you in a lie, right, to try and undermine your credibility. And what I just saw the same insurance company do was surveil someone, tell them they surveilled them, give them a chance to explain in the interview, and then move forward with the claim process. So the second process was done under California law on a non-ERISA claim. They clearly wanted to avoid the perspective of treating a claimant with bad faith. They didn't want to appear to try and give a gotcha. The choice to surveil a claimant is something they can do, and finding it and then giving a claimant a chance to explain, that's not an unreasonable thing to do. In ERISA, again, in comparing that to the ERISA claim managers, they're looking for ways they can nitpick you and undermine your credibility, even if it doesn't have anything to do with what you're stating. If you say you can only garden 20 minutes a week, they catch you gardening for 30 minutes a week, they might use that to say you exaggerate your limitations, even if you were just having a good day. So that's the other, big differences as far as how it affects people is in many states, when you have an ERISA claim and you have to litigate it, depending on the state and what your policy says, in a normal lawsuit, in order to win, you win by a preponderance of the evidence, which is numerically basically 51%. You win versus the other person's 49%. And that's how most cases proceed. If your case is in several states or certain states and your policy gives you what's called discretion or gives the insurance company discretion, it makes it so that in order to win at trial, you not only have to show the preponderance of the evidence standard, which is you were right and you actually are disabled, you have to meet this higher threshold of proving the insurance company's decision was not only wrong, but unreasonable, which is called an abuse of discretion. And this was one of the biggest obstacles for most people, again, who don't necessarily care about getting the punitive damages. They just want to get their benefits paid. That even if they were clearly disabled, they had to show the insurance company did something wrong in coming to that conclusion. They either had to show procedural problems, they had to show recklessness as far as, not reckless, but almost negligence in how they assessed the claim. And that extra standard to me not only is really difficult, but it makes it hard for attorneys to even agree to take the case because they review it and say, we agree you are disabled, but we can't connect the dots to show that they actually did anything wrong. So it created, again, this massive disincentive for people to even be able to win their cases in the first place. And insurance companies, knowing this, they say, okay, well, if we lose, or when we deny the claim, what we're facing is these people have to face this massive uphill climb to even win the case. And worst thing that happens is they win. We have to pay what we paid anyways.
Yeah, I love that. So that's a great explanation. Let me jump in and give the real life example on my end, and we're going to go through maybe a couple of more examples later of situations. So when I first got long-term disability, I thought, oh, okay, great. So I'm just going to get this check and that's fine. And then every time they messed with me, I would threaten back, I'm going to sue you for bad faith, intentional infliction of emotional distress, breach of contract. I was just, amateur lawyering it. And they backed off because for a few years, they didn't realize it was ERISA. And then a few years later, the insurance policy moved to another company and they must have caught wind. They're like, oh, this is ERISA. What are you doing? And they started messing with me more. And I would threaten those things back. Like, I'm going to sue you for this. And nothing happened. And I'm like, what is going on? Like, they're not backing off. And so that goes to that point that you made earlier about, as a person who, if it wasn't under ERISA, which they made a mistake there, the claims people didn't see it for the first couple of years, they would have come much harder at me and they wouldn't have backed off. But because they thought it wasn't an ERISA policy, they thought I had these remedies to just go take them to court. Then they realized it was ERISA. They started messing with me. And here's what they did. And I want you to, on the other side of this, explain why it's in the confines of the insurance company's sort of like amateur legal system, and you'll get this when I say it. One day, I just got a letter that said, hi, from the insurance company. Hi, we've got these people that you've never met. Like, here's a doctor, here's an occupational therapist. They've looked at your file after 10 years. You're not disabled, so we're canceling your benefits next month. Bye. And they just canceled the benefits. And I was like, what? And then I called an ERISA attorney. I'm trying to figure this out. And they're like, yeah, so now you have to go through a 6-month appeal system with the insurance company. I didn't have the right to go get an attorney and just like sue them in the court in California. I had to go through their appeal process. I went without my money for 6 months. And like you said, all they did at the end of it was just pay it back. No interest, no nothing. And they sent me to one of their doctors. I had to go in there. He said I wasn't faking it, thank God, but it was a whole thing. And so for 6 months, I had to get out of my apartment, sleep on a friend's couch. And what I'm bringing up there, I have a hand disability, but there are people who in that 6 months are getting treatments for things that can kill them. And then they die
Mhm.
during that appeal process because the insurance company, I mean, I'm going base here, but the insurance company will be like, right, we don't think you have cancer. We have 3 doctors here. And you could be like, well, hold on a minute. I got 5 experts that say I do have cancer. And they're like, sorry, you have to go through appeal process, and then you don't get your treatments or the money for 6 months and you die. And I know there's been cases that extreme, but I just want you to come in then and kind of explain, like, that's really the difference, right? I felt like I had less rights. I was horrified when I found out. And I know Glenn said there might be advantages to having an ERISA policy in other states versus California where we have these remedies, but it seems so unfair. Like I didn't have the legal system at my disposal. That's how it felt.
I'm sure it did, and that's correct. Uh, Talk about the appeal for a second. When ERISA was passed, it directed the Department of Labor to promulgate rules on what the insurance company had to do in evaluating claims. And one of the rules was if you're going to deny a claim, you have to offer the insured the right to appeal the denial by giving you more evidence. And that sounds like a good thing. Well, if they deny me, I get a chance to say, well, here's more evidence to show you I'm right. However, the courts then down the road took that right and made it mandatory. And it used to be you only had 60 days to appeal. Now it's 180. But the point is, the insurance companies will write you a letter that says, hey, you may appeal if you'd like. What they don't do is say, and if you don't appeal, you can't file suit, which is what the law is.
And you lose everything. So if you miss the window of appeal and you're past the 180 days and you don't know better, then they're like, sorry, Charlie. And I can't take it to court and go, hey, they did this to me because they're like, sorry, these are our ERISA
Right.
rules.
And you would think the courts would say, you have to tell these people that if they don't
Yeah.
appeal, they can't file suit. But no court has ever done that. So it's imperative that you follow these rules and you know these rules. Now, you mentioned getting an attorney. You are allowed to get an attorney to help you do the appeal. But people who are already on disability are not getting any income. It's very hard for them to find a competent attorney who's going to be willing to help them. People don't have the money to pay an attorney, so the attorneys that do this typically will do it on a contingency basis. But there are not a lot of attorneys out there specializing in this area of law, so it can be hard to
Mhm.
find an attorney. As you said, there are horrific situations.
Can you give us a couple examples of like some of the worst ones that you've seen?
Well, yeah, I had a woman who was diagnosed with stage 4 pancreatic cancer who'd had an operation called a Whipple, which is extraordinarily complicated and dangerous. Uh, and the insurance company just said, no, we know you're not in remission, but we don't see any reason why you can't work. I mean, this woman was dying. And I actually he said, I'm going to take your appeal for free. This is ridiculous. Somebody's made a mistake. And I appealed, and they affirmed the appeal. And I filed a lawsuit. And within a week, I got a call from the lawyers for the insurance company basically saying, okay, we want to settle this. Because what you get are sometimes high school graduates who are making these decisions, and they're either
Yep.
making stupid decisions or they're making evil decisions. I could go through a whole algorithm that the
Right.
insurance companies, if they've got 100 claims and they should pay all of them, but they deny them all, they know that 15% of people will give up right then and there. Another, 20% will appeal, and if it's denied, excuse me, they'll give up. Then you've got another percentage who will hire a lawyer. Some will get good lawyers, some will get bad lawyers. Some will get assigned to consumer-friendly judges. Some will get assigned to companies who are very much in favor of insurance companies. So, well, I've never seen the actual internal numbers. I have a suspicion that if the insurance company decided, well, we'll pay 100 and it might cost them $30 million to do so, if they deny them all, in the end, it will cost them maybe 5 million. So all this is, from an insurance company's perspective, is a business decision. I call it insurance fraud. They call it good business. I mean, in the non-insurance context, I'm sorry, in the non-ERISA context, I'm often called by people, frequently doctors, dentists, consultants, who say, I've got a very significant condition, MS or lupus or a back injury or even cancer, and I'm going to make a claim. And I've got an individual policy. I'd like to hire you uh, to make this claim. And I tell them, you know what? You don't need to make your claim. They're not going to deny you. In reality, what could be the best thing to happen to you if you're in California is they would deny your claim because we could sue them for millions. On the other hand, if the same doctor works for um, a private hospital, he's limited to the benefits and it could be a tough fight.
Well, I also want to talk about the surveillance. So I've been surveilled and all that kind of stuff. And so I have a hand-arm disability, and when I was in chronic pain for the first couple of years, I couldn't really wear a purse or anything, so I'd wear like a light backpack because just the even pressure was better on my shoulders. And they did that too. They're like, "We need to interview you," and they'll often write you a letter demanding or telling you something that isn't true. Like you have to, because your policy states that you have to do this, and then you're scared and you go, "Oh my God, I guess I have to do this." And so what happened is they were like, "We need to interview you." And I met them in downtown Chicago in a lawyer's office. The lawyer obviously wasn't that great. And they were just private investigators trying to catch me, like you said. And then I walked out of there and they filmed me. And the report that they submitted was she was using a backpack. Her arms are fine. They obviously work. And again, it's not about them working, it's about whether I'm able to do my job. And so they'll just do anything. And that, if they were to continually do that, it's like you said, when I was threatening in the beginning, like, "Hey, I'm going to sue you for this," the intentional infliction of distress, like how I've had them harass me and be like, "What are you going to do for the rest of your life? You're going to be lazy and just not fucking work." And I'd be like, "Oh my God, like what?" Like that is harassment. But I had nothing, I had nothing no remedies. And so when I think about ERISA, it seems like such an unfair thing. It seems like it's kind of like your benefits don't have benefits, but I see that depending on the state you live, it could be more beneficial to have the ERISA policy. But what you're saying about the California thing or other states that might have these remedies is the reason they're scared that they don't want to deny the claim and why you're saying you don't need attorney is because they're afraid of getting like millions of dollars, like bad faith and all of these remedies that you don't have under ERISA. Um, I I'm wondering about this move, and I know this is kind of specific, but some of these policies are own occupation. Like if you can't go back to the job that you had, like your doctor, you can't go back to being a surgeon because your hands were amputated, then you get this insurance from, until you're 65, 60% of your income. But then they stop selling those policies. Like I have that dinosaur policy, and then nowadays, I believe, I could be wrong, but that they sell ones that say, well, we'll do on own occupation for the first 2 years. And then after that, it's gonna get rough. Can you tell me about that nuance a little bit?
Sure. And you're correct. The vast majority of group policies sold to employers provide they will pay 2 years if you're unable to perform your own occupation. After that, they'll pay if there's no occupation you can do for which you're qualified by education, training, and experience. And from the perspective of the insurance company, uh, there must be 5 million jobs out there to be a surveillance monitor or a surveillance camera monitor where you just sit there and look at cameras. Uh, it's can be an onerous standard. They don't really care how much you can make, and they don't care what you used to be doing. Um, I just had a doctor call me the other day who was an ER physician who had a grand mal seizure and said, I'm not safe to be treating patients. And they paid him for 2 years. Then they said, well, you can be a Zoom doc and give people advice over Zoom. Because if you're not, even if you have a seizure while you're on Zoom, you can't hurt them. It's ludicrous.
Let's get into that a little bit more because I guess I would say I'm going to play devil's advocate for a second and say, well, hold on, Glenn. Like, well, so they can do that job. Like, I'm playing the insurance part right now, but like, they could do that job. They could just sit in front of a surveillance camera all day and watch stuff. They don't have to use their hands or worry about a seizure or whatever else it is. Um, why is that? I mean, that seems wrong because you're like, well, I've spent 10 years of my education becoming a doctor and all this kind of stuff. But can you just sort of talk around that a little bit? Because it seems, how do you fight that? How do you fight that kind of thing? What do you say to the insurance company on that? Like, what's the argument for like, no, you can't just tell me I can sit in front of a camera. You know what I mean?
Well, under ERISA, the courts are supposed to adopt a body of insurance law, and they're allowed to take from the state law in certain circumstances. And in California, there's a standard that for the any occupation, it has to meet your station in life, which is, in the classic example is they can't have a doctor selling apples on the street corner, which is obviously a very extreme example. But the better example is my physician who trained to be an ER physician, and they can't make him uh, a Zoom doc. There are nurses who've been on a cancer ward for 20 years and they have a back problem, and the insurance company will invariably say, you could work for an insurance company reviewing, and then it'll say it, but what they say, reviewing and denying claims. So they, under California law, which has been adopted, they have to at least kind of look and see what you were doing and make sure that it's the same level of occupation.
Can they do something like, well, there's YouTube and social media, go become a YouTube star? Or does it have to be like a job that you're hired for? I'm just imagining that they would throw out
No,
anything.
they cannot just throw out anything. They can try, but they won't get away with
Right.
it in court. For example, I had a lawyer as a client, and she said, I think I want to write a book. Is that going to prevent them from paying me my disability? And my answer was only if you sell a bestseller. The fact that you can sit and write a book does not mean that they can terminate your benefits. You have to be able to earn a living at it. So, they
Aha.
can't say to a doctor, well, you know what? You could probably go back to medical school and become a lawyer. They also can't say to a doctor with an own specialty policy who is a brain surgeon, well, you could practice as a pediatrician if his hand shakes. That's okay. So there are protections in certain areas preventing them from doing that. The biggest one is typically the policies will have an income qualifier. And typically
Yep.
they'll say, if we're going to pay you $10,000 a month in benefits, if you can find a job paying you $10,000 a month, that works for any occupation.
I had an experience where in the, "Hey, sorry, we don't think you're disabled. Now you can appeal it for 6 months." They brought up the Dictionary of Occupational Titles, and I think it's called something else. And so I was in the computer industry and we had to use the keyboard and type, repetitively all day long for at least, 8 hours a day. But even though the company had checked off like she has to use the right hand 8 hours a day, the left hand 8 hours a day, because it didn't say keyboard in there. They looked up the Dictionary of Occupational Titles definition for a technical recruiter, which is what I was. And they were like, oh, this explanation from the Dictionary of Occupational Titles from the government says there's no keyboard use involved. And that's where it gets crazy, right? Because they're comparing something and language, and it's tricky and it's semantics and it's bullshit. But then you have to go and fight that. But that's another interesting game they play too. Can you talk about that move, like them comparing it to other job descriptions?
Well, first, the Dictionary of Occupational Titles has not been updated for 30 years. So, if your job
Mm.
is a computer programmer, that didn't exist 30 years ago. And the courts have caught on to that. There's something called ONET now, which is more up to date, and they're supposed to look at vocational assessments. But what's interesting is ONET is proprietary. It's created by a private company. So the insurance company will say to you, well, under ONET, it says that you have the ability to do X, Y, and Z. And the insured will say, well, show me where it says that. Oh, we can't show you that. That's proprietary. So it's like double secret probation from a
Right.
movie. They're going to tell you why they're not paying you, but they're not going to give you the evidence. And courts are not too fond of that.
I remember to combat that, what I personally did, they were like, sorry, technical recruiter, the description says no keyboard use what at all. So I guess and that's our third argument. And so what I did is I pretended to be a graduate student from UCLA. Just completely acted. I called up all of the major recruiting companies in various major states and cities, from even the state and city from where the insurance company had denied the claim. And, all of these big recruiting companies, Apple one. And I was like, hey, I'm a graduate student and I'm doing a study on ergonomics in the workplace. And I just have a couple of questions. And do you mind filling out this little survey for me? And what the survey was exactly what my HR person had filled out, which was like, how many hours a day do you use your right hand or your left hand? All of them came back that they all had to repetitively use their hands, both hands, 8 hours a day. I got over 30 of these. That is what I submitted. Now, I don't know that anyone's done that move. I'm just sharing it in case anyone wants to pull it at some point. The other thing that I did, and again, I don't recommend that anyone does this on their own, obviously, but the other thing that I did is I was so many years into this and I was fed up. So what I did is I found out who the head legal counsel was for the entire insurance company. And I called them and I sent them an email and I go, you better talk to your dumbass claims people in Nebraska because here's the history of your case. You're going to look so stupid publicly and in court, and you better take care of it. The next day, I got a call from the settlement department. I mean, do you know what I'm talking about? And then they just continue to pay the claim. It's like you have to bully the bullies, but it's stressful to do it yourself. I've sobbed so many tears every time I get a letter, every time I had to go prove what I've already proven, right? Every time, I mean, I have 5 hand surgeons, from all different cities. At one point, I thought, if I had the money, I would go to every country and get a hand surgeon, just like overwhelm them. But that's the other thing too, is overwhelming them, finding these ways to get extra evidence to combat it. It's a lot. It takes a lot of time, and the emotional pain it's horrible. Because every time it's like you're saying I'm a liar. You're saying I'm a liar and you're trying to get out of something. You're breaching a contract that you made. You didn't have to agree to this policy, but you did. And that's how it feels as someone who is in that situation. But that's why there's you guys. You have to have powerful people who are, I don't know how you guys spend every day not being horrified. It's almost like cops or firemen. I'm like, I don't know if I could even be around that all the time. It's such contentious stuff. And like you said, these claims people are, they're just, swiping by. They're not necessarily educated. They're young. They're just doing their job. I would bark back at them too and say, how do you sleep at night? I just remember having to berate them, be a bully. If you read the letters that I've written to my insurance company, like they're horrific. Like I would be horrified if I were reading them. Like I'm actively almost inflicting distress on them. But it worked. But it's a lot of work and it's lonely. And I didn't really know everything and I got lucky and that's great. And then I became a public figure and, I'm sure they don't want to mess with that at that point. And they were like, all right, we're just going to leave her alone because it had been so many years. But the people in the first 3 to 5 years, right, I feel is like the most important time. Andrew, I know you came back in here. Glenn, what did you want him to touch on? Or Andrew, do you want to offer up anything in this discussion that you were thinking of before you left?
Yeah, sorry about that. Technical glitches. So a few things. One, I think your experience is unfortunately somewhat typical. Certainly as far as the customer service experience. And in fact, I think in some ways you're lucky, and I use air quotes, virtually, in that you had a disability which was clearly definable, clearly objectively measurable, and sounds like scientifically known, as a lot of mechanical injuries are. And even if the insurance company tries to go out of their way and say, yeah, this doesn't, these MRIs don't mean that, like it's very hard for them to find a doctor to actually support that, arguably. And I point this out because a lot of our clients are not so lucky in that. And a lot of people are facing disability denials. If you, especially, lately when there's fatigue illnesses that people are experiencing, before COVID, there was already a lot of chronic fatigue
Yep.
cases, and before that, fibromyalgia cases that were being denied pretty much by default. I mean, they would say, no, I don't care what evidence you have. I don't care what you've done to treat it. I don't care what your doctors say. There's no objective evidence that you have fatigue that's bad enough to impair you, so we're not paying the claim. And once COVID hit, ironically, after COVID hit, there was a lot more COVID-based claims, which overlap significantly with the chronic fatigue syndrome claims. And so a lot of people were experiencing both. And to some degree, the COVID claims and the inability for the insurance company to say, well, we don't believe COVID exists, gave a little bit of credence to some of those claims. But it's still the easiest thing for an insurance company to target these people and deny them. And you point out that they make you go to an IME. That's a very common trick for a few reasons. One, a lot of people are just too scared. They won't even go. And then the insurance company can automatically deny them and just say, hey, you didn't comply. We're denying. Another common trick is that, oh, you have chronic fatigue syndrome. We'll send you to a spine doctor to have the spine doctor evaluate you. Spine doctor will say, well, yeah, I observed this person for 2 hours and there was no measurable deficits that I could see that would lead to this person being disabled. Well, of course there's not. That's not how you measure someone being disabled from fatigue. So these systemic things that they do are all part of the process to just weed people out.
Let me ask a question about the independent medical evaluation, IME. So like when during the appeal, they're like, and we want you to see our doctor, right? So I went into that doctor and the doctor said she's not faking it. However, at that time, I called up an ERISA attorney and I was like, hey, I got to go in here. And she was like, you know what? I think you got this. Let me just guide you. Very nice. She's like, I just think I just guide you. She said, go in there with a witness, have all your shit in a binder, lined up, like organized, show that you're on top of it. And then she said, what's the doctor's name? And I told them and they go, oh, yep, we know him. Yep, he's a regular. Now this, and before, when I initially filed a workman's comp claim when I first got injured. When I went to my workman's comp attorney, she asked who my doctor was. She pulled out a physical list, a piece of paper. Back then, there weren't really MacBooks. And she was like looking down the list. She goes, oh, good, he's not on here. And I said, what are you talking about? She goes, this is a list of doctors that are in the hands of insurance companies. This is scary and frightening and awful. But I want you to tell me, what is that about? What are they getting paid? Like, what's going on there? Why would a medical doctor knowingly say that a person could work when they can't? And just talk to me about that, because that was the scariest thing for me to learn.
Yeah, absolutely. So this phenomenon happens in two general forms. One is that different insurance companies do it differently. One type of insurance company will use in-house employees. They're called medical directors, or they're called, medical directors or in-house physicians or whatever. They literally use their own employees. And so in a lot of situations, I think a lot of people can imagine, okay, well, someone's full-time employed by this company, their bonuses are tied to an unit, and their bonuses used to be directly tied to these things, where literally the more you deny, the more bonuses you get. That stopped because lawyers would start to use that in discovery. But the reality is, even if you stop tying bonuses to it, who's going to get the promotion? The guy who, the doctor who's denying more claims, or the doctor who keeps fighting for the claim reps, right? It's
Right, the doctor who saved everybody 30 million, or the right.
Exactly. And in fact, when it comes to certain insurance companies using the same doctors over and over again, it gets so bad. I mean, I have certain names in my head that I can pretty much expect to see in certain insurance company files. I also can tie some of them to specific arguments. And I can say this openly because we've used these arguments in court, tied these names to these arguments, and said, hey, after we've won these cases in court, and the judge has said, you can't, this argument doesn't make any sense because it's wrong and it, defies logic and medical science. They still use the same exact argument. The same person continues to use the same argument again and again and again. And we've brought that lawsuit and said, hey, just like we said in this lawsuit, they're doing the same one in this situation. The best result, as we've said in most ERISA cases, they get paid. There's no punishment for that, where they would never think of employing that obvious practice in a non-ERISA case, because they get that. I mean, that's pretty much an open gateway to opening the door for punitive damages. So there's companies who hire and just use their employees. And I think it's easy for a lot of us to understand how that system ends up being so, biased. And they don't hire the best doctors from the best hospitals. They hire, they put out high salaries, not good. You don't need, we don't care where you are in your class. We don't care what your medical reputation is. Maybe they're hiring people who've made a few mistakes in different hospitals and can't get employed anywhere. Maybe they're hiring someone who failed in private practice, or basically, you think, what kind of doctor would take a job like this? Well, probably not a doctor who can get a better doctor job and someone whose morals are a little bit different than yours and I's. But that's how it works in a company. The other way it works is, which is somewhat more common, is these insurance companies will hire peer review companies, basically third-party vendors, so they can say, oh, these people aren't our employees, they're independent reviewers. But they hire the same companies over and over again. They choose from a list of people the vendors provide. They have their internal statistics about the vendors, and they're like, this is the person we know is going to give us what we want. And just because there's a vendor filtering through the process doesn't all of a sudden mean, oh, now they're truly independent. As soon as they, frankly, from what we've seen, as soon as we catch or they accidentally provide an independent provider who gives a good report, we never see them again. I've never seen it. Happens once in a while where an insurance company sends someone to an IME. I look them up. It's like, oh, this person's been the head of medicine at this hospital for 20 years. I've never seen their name before. I think you should go. And they give a good report and they actually say the person's disabled. Never seen that person twice. Never seen that doctor twice. We see repeat doctors enough through the peer review system that we have, we're able to basically object to them at this point when we continue to represent clients by saying, we don't trust this person. The courts have actually found this person's assessments to not be reasonable or viable. Here's a list of people you can use. Feel free to send them to these people. 9 out of 10 times they back off. Well, I couldn't say that. If they do back off, which is sometimes, 9 out of 10 times, they don't bother pursuing the people we offer. They'll just back off and not get a test at all because they're not going to spend the money to go send you to a good reviewer. And it's the same question. What kind of doctor would choose to work for a peer review company, reviewing paper files and checking off, I think the kind of doctor who isn't going to get a job doing the things that most doctors want to do. So
there's another point, Al, that you brought up. I think your listeners need to know. We talked about the appeal process before you file a lawsuit in ERISA. Only the information that the insured gives to the insurance company during that appeal process will be considered by a judge. So a lot of people will say to themselves, you know what, I don't want to hire a lawyer. I'll do the appeal myself. Some will just say, hey, I appeal, and they get denied. And they come to the lawyer and say, will you go fix this? And the answer is, we can't fix it.
And that's the bummer about that. And I remember learning that from the attorney back then during that appeal. She's like, you better get every piece of evidence into here that you want into this appeal because you won't have a chance to offer more later. And I was just like, man, that was really brutal. The doctor, I remember one time being in a grocery store and the woman had, anytime I see anyone with a hand thing, because I have a hand disability, I'm always like, wait, what's going on? And I saw a checkout person at a well-known grocery chain in California, swiping, and she had a wrist guard on. And I said, hey, are you okay? Because, I have a hand disability and I knew her for many years. I'd seen her. And I go, what's going on? Why are you working? And she's like, oh, I went to the doctor and they said it was okay. And I go, what doctor did you go to? And she goes, oh, I went to the company doctor. And I was like, no, you know what I mean? I was like, no. So is that a warning that we should give everybody, that if you're at a company to not go to the doctor they tell you to go to and to go find your own doctor?
Well, the workers' comp question is a little bit different. So if you're injured at work, you can simultaneously be injured at work and become disabled from an injury at work and have a long-term disability claim and a workers' comp claim at the same time.
Right.
In order to get any kind of workers' comp benefits, you have to go through the workers' comp system. Now, what I find from a lot of people is they think that the only care they're allowed to get is through the workers' comp system. For most people, they don't have the option to just say, I'm not going through the workers' comp system because that's the only way to get any workers' comp benefits. You have to go through that system. But that doesn't mean you should rely on the workers' comp system to give you support for your long-term disability. If it's supportive, fantastic. Bring it over and send it in. But you can't necessarily rely on the workers' comp system to be sufficient to support your long-term disability. Not only because it's an adversarial system. You've got the workers' comp doctors who are equally as adversarial to you as the LTD doctors, but they're looking for different things. As you may know, the workers' comp system has the kind of a body part rating based on limitations per body part, which is really specifically designed to measure compensation, treatment, things like that. It's a really different question in a lot of ways than the long-term disability standard, where someone could have a limb completely, completely unable to use one limb, but somehow can do their full-time occupation. And both things, those things can both be true. You can also not have any identifiable damage from workers' comp, but still be disabled from the impact of the job, even if it's not technically doesn't technically qualify under the workers' comp standard. I think the big lesson is don't expect to get sufficient care through the workers' comp system, and make sure you get the care you need outside of it, however you can.
Since you were off because of tech issues for a bit, Andrew, tell us some of the most like just egregious situations or cases in your mind that stick over all of these years of doing it. That I know Glenn has shared a couple, but what stands out to you in these scenarios?
Oh, so there's a few special ones that definitely stand out. One of the ones that really stands out to me is there was a situation basically where someone they worked at a really high paying, high stress job, and had a heart attack. They had some kind of heart event, almost died. I mean, they were in the hospital for a while. When they got out of the hospital, the doctors basically said, look, we've saved your life. You need to avoid all stress. And we're not saying this like stop eating red meat. Like if you get stressed in this, I think it was either an artery repair or something. If this erupts, you'll die on the spot. Like you cannot be anywhere near any kind of, so, and he said, well, what about my job? What about your job? You cannot be anywhere near your job. Your career's over. Um, and so basically she files a claim and says, look, if I work, I'll die. So I'm disabled. And they said, well, wait, hold on. Just to be clear, you're able to work, right? It's just that if you do work, you'll die.
Oh,
And he said, well, yeah, I guess I technically can. I mean, there's nothing physically restricting me from being able to do it, but yeah, it puts me at a constant threat of death. And they denied that claim and made us fight it and basically said, look, the standard under the policy is the inability to perform the material duties of your own occupation. And this person could do it. The fact that they might die while doing it doesn't mean they shouldn't get paid. And that one, um, that one didn't go to trial. We resolved that one, but that was a really special one. The
oh,
the other the other one that really stands out is it involves surveillance. And in this case is one of the first cases I handled. Basically someone's on disability for 9 years after a horrible car accident, which results in surgeries everywhere. I mean, she's just in a ton of pain, and she's on multiple narcotic painkillers for 8 or 9 years at this point. Um, and at some point, she, instead of complaining about the side effects of the narco and all this stuff, every time she goes to the doctor, which she did, she kept complaining. It made her loopy. She couldn't focus on it. Like she certainly couldn't drive on it. Um, she just stopped complaining about it. The side effects didn't go away. It'd been 8 years. She just said, it's still taking the narco, still the same side effects. Doctor, just stop recording the side effects. Apparently, the insurance company sees this and thinks, oh, maybe she's getting better. So they surveil her. They see her taking a trash bag full of something and what they call effortlessly throwing it into the trash can.
yep,
And they estimate that the trash bag must have weighed as much as an average trash bag does, which is 35 to 45 pounds. And she claims she has neck and shoulder issues. She could never do that. We help her appeal, and she very clearly explains, first of all, I'm still taking a ton of drugs. I haven't stopped taking them because I stopped complaining about them. And of course, I still have the side effects, and I can no longer be a lawyer or anything else because I'm on these medications. Even if I wasn't in pain, I can't focus. And that trash bag you were describing, that was the weekly recycling. And yeah, I was able to hoist it up as I do because it weighed about a pound. It was empty
right,
plastic water bottles. We explained this to them. I mean, and we put together, I did it myself. I was very proud of that appeal. It's about as good as an appeal gets. And they,
right,
they pretty much rubber stamp denied it. The arguments were the same. They didn't bother looking at it. And they even said that some of our appeal evidence was not time contemporaneous because it was submitted 4 or 5 months after the denial, but they give us 6 months to appeal. So wouldn't you think anything we submit that's within 4 or 5 months should be time contemporaneous? Otherwise, what's the point?
right,
They deny it and make us go to litigation, and thankfully the judge ruled in our favor and tore them up pretty badly. But the reality is this appeal that you're given, it's just as often a chance for them to shore up their denial and
yep,
cross T's and dot I's as it is for them to reverse. And I think, the formula to reverse a denial, it's it it should be a lot more accessible to people than it is. I mean, the fact that you usually do need a lawyer, both because you need to know the right strategy and to make sure to get the right evidence in, it's not fair. People shouldn't have to pay a lawyer to be able to do this. Especially, when you think about the way the laws evolved, it all started, it's the employment retirement income security. It's supposed to protect employees, and it literally evolved to do the exact opposite. And the appeal is a really good example. Doesn't matter how much time you get, it takes you farther away from the date you're arguing about, and then they argue that the evidence doesn't come close to when you were denied, and so it's not as relevant.
Yeah, also I want to point out too, just as it popped into my head, so a lot of these large insurance companies, the Hartford, Prudential, Lincoln Financial Group, we see these beautiful ads on television. You're like, this is a known company. They're all doing it, right? There is no good one, is there? You know what I mean?
Uh,
Like they're all pulling the same moves, right? It's
that's a tough question. I will tell you that there are 10 major companies that do this. I do have views as to which are the worst. And which,
gotcha.
for example,
Are you allowed to share that with us, what you think are the bad ones, or is that too much to say?
I think that's a bridge too far.
Yeah, it's probably a bridge. I
I
gotcha.
will tell you though that when I went out to buy long-term disability insurance for my law firm, I felt I knew who to go to because in 25 years I had a reason to sue them once, but I called them up first because I thought they made an egregious error. I got a call back the next day from this insurance company saying, basically, oh my God, we're sorry, you're right. And this was an ERISA case. So they could have said, no, go away. They said, we don't do this. This was a mistake. We're fixing it today. That's who I bought insurance from. Um,
That must be kind of an interesting, like, you guys are people that sue these companies for denying this, and then you have insurance through them. I mean, I would imagine that they don't deny any of the, like, lawyer claims but, I mean, even though they said they did something wrong there.
but this was a
Um,
good company. We've handled lots and lots of lawyer claims from various
Oh
companies.
yeah.
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 And I would tell you,
Wha
sometimes we have cases that are almost kind of fun. Your listeners might enjoy it. It's like I had a bad faith
yeah, I love it.
case, not ERISA, where my client had a
Can you just explain bad faith again? It's them, like, falsely, fraudulently telling you you're not disabled when they know you are, and it's some bullshit excuse, and that's bad
yes.
faith because
Well,
it's not legit?
it's
Okay.
just an unreasonable denial. It's not a simple mistake.
Yeah.
It's just unreasonable. They don't look at the evidence, or they don't check
Right.
out the evidence. I had a case with a woman who had an extremely bad back, and they were paying her for a while. Then all of a sudden they said, we have reason to believe that your back is nowhere near as bad as you say it is. We're denying you. And because it was not ERISA and I had seen her medical records, I just filed the lawsuit. And as the courts require us to do, we went to what's called a mediation very early on, where you try and get the case settled. And the lawyers were very bullish for the insurance company, and they pulled out a computer with a surveillance video and said, look at this. Your client is lugging these very heavy trash cans down the driveway. There's no way she could be in the pain she's talking about. And I look at it and I think, well, you're right. That doesn't make sense with the story she's telling. And then I take that video into my client and showed it to her. And she said, well, yeah, if that were me, that's my twin sister. She comes over to do this for me because I can't do
Oh,
it.
it's beautiful.
I took it back into them and they looked at her and they looked at the computer and they looked at her and said, we made a pretty bad mistake here. And they not only paid her benefits, they paid her a substantial sum on top. If it had been ERISA,
Mhm.
they would have said, okay, we blew it. No harm, no foul. The fact you had to hire a lawyer and pay him a big chunk of money, not our problem. So, I mean,
Wow, the twin
Yeah.
sister, that's a good one. I guess you could always be like, "It was always my twin." Like, they're
Yeah,
all
that's what anyone can say. You have to prove up the twin next, right?
right, right, right.
That's our next appeal strategy is figure out a way to give everyone a twin so they don't have to worry and have someone their trash
Exactly.
cans for them. And to clarify, when we say bad faith, like a bad faith case, it's what we colloquially describe as a non-ERISA case that's governed by state law. And what it means is that, and as we were describing, it's the tort that allows you to get extra damages from an insurance company, and it's called a violation of the covenant of good faith and fair dealing, which we of course condense into bad faith. And so when you're thinking of, suing for a case that's governed by state law, you ask two big questions. You ask, did they breach the contract? Meaning, is this person actually disabled? And the next question is, was their conduct so egregious and unreasonable, and it's specified in statute what qualifies as that? Should the person be entitled to extra damages? So there certainly are cases where a case is governed by state law, and we assess it and say, yeah, the insurance company was wrong, but we don't see bad faith here because their decision was reasonable. Like, we understand why they came to this conclusion, and we think we can fix it, or something like that. But usually, when it comes to long-term disability cases, if someone says they're disabled and the insurance company denies you anyways, there almost has to be bad faith there, because for the most part, you are the best arbiter of whether or not you can work. And if you say you can't and they say you can, well, chances are there's something missing. And it's very rare, in my opinion, that there's truly not enough evidence for a reasonable person to decide that this person can't work. It really, they put you to a standard which is far beyond what you would expect a reasonable person would have to prove, especially when, if you're a human being taking a step back, thinking this person's disabled, having to prove this disability right now. We're putting them through this process, which is really hard. And this is not a fully functional person. This is someone who's already disabled enough to not be able to work, which, again, in America, to be disabled enough to not be able to work is pretty bad, because we, by default, love to push through everything. I mean, sure, maybe it's the same way other places, but I think it's a very
Yeah.
American thing to feel this commitment, especially to your employer, to your job.
Or your worth being attached to it. People feel like
Yep.
you're a loser. When this happens, you feel like I'm a loser. Everyone's working. I mean, even though it's not your fault you got disabled, but I'm sure you've heard these emotions from clients. Yeah.
Yeah.
Quick question, Andrew. Because when I think about breach of contract, like someone trying to breach contract or attempting to, it seems like it's mixed. To me, it's like, what's the difference between bad faith and breach of contract? Because it seems like bad faith is used to breach a contract, or am I like, can you clarify you get what I'm saying?
Yeah, I do. And the law makes a pretty significant distinction, because in the insurance context, it's very easy to see an insurance company breaching a contract because they're in the position of power. It seems almost by default like the assumption of bad faith is a lot stronger. But if you kind of take a step back and think about kind of the basis of contract law, a lot of contract law is, you said you'd send me 1,000 widgets and you sent me 1,000 wojits, right? And it's like, okay, well, I meant to comply, and there isn't the same dynamic of I'm trying to rip you off.
Right.
In a lot of contract law, a
Okay.
lot of it is really just trying to make sure. Now, I think you bring up another question: is should people? I mean, there's the other question of, if people in contracts breach it, are they always committing some kind of bad faith? Maybe, but the question is did the insurance company commit bad faith that's so unreasonable as to justify the tort? Is responding to something in 46 days instead of 45 days bad enough to constitute a tort? Probably not, even though it, may be a breach. Is denying your claim by ignoring all your doctors and then selectively picking medical records which favor them and ignore you a bad faith? Yeah, that definitely is. And it's obviously both. So,
Can I ask a question? So I know we're going to wrap it up here in a few minutes. I've got a couple things I want to throw out there. So you mentioned at the beginning, but not surprisingly enough, but considering that ERISA is more restrictive generally than having your own policy, not through employer. The only people exempt from this are members of Congress, correct, or religious organizations. I would love to hear why they didn't include themselves in it. Because they knew it was garbage, or what? Back then,
huh.
because it was 1974. But still, like, why are they exempt from that, and why do they not have to
Well,
have it?
I want to correct you a little bit.
Yeah.
They didn't
Okay.
just exempt members of Congress. They exempted what are probably 10 to 15 million governmental employees.
Oh, so any government employee.
A
Okay, got it.
school
Yeah,
teacher,
all of
a
them.
Gotcha.
trash collector, anybody employed by a governmental entity. So it's not just Congress. Yeah, Congress has their own plan, and of course they get paid.
Right.
Um, but
Yeah.
I think first, if you remember, I told you at the start, the law was passed to protect pensions, and they figured, well, the government, their pensions, Social Security is all set up. There's no reason for the government to have to comply with these rules. And they also
Hmm.
wanted to exempt churches because they just thought churches were a special category. But I don't think there was anything nefarious when it was set up
Okay.
that way. It just has turned out that governmental employees can do much better if they are improperly denied.
Gotcha. Okay, yeah, because that's sort of where I was getting. And then anything else that has come to mind that you feel people should know about this process or about insurance companies? I know there's so much here. We could go on. You could go on for 10 hours about it. Andrew or Glenn, anything that comes to mind you'd like to share as we wrap it up?
Yeah, one thing I'd say real quick is, we were just touching on mental health and the impact all this has on mental health. One of the things, anybody considering filing a disability claim should look at is their policy and whether there's a mental health limitation.
Hmm.
Most policies will have a 2-year limitation, which only pays 2 years of benefits if you're disabled from mental health issues. I point you first to that, and I also point to, most people who are disabled for 2 years or more have mental health issues as a result. Like most people who are not working and are in pain or suffering in some way, are at some point advised to get mental health treatment or get it on their own. It's an easy way for an insurance company to try to limit their exposure to an otherwise claim that should otherwise be paid to 65 years by saying, yeah, we acknowledge that you have, back and neck issues, which you claim are disabling, but we think you've been disabled by your depression the whole time. So we're only paying you 2 years of benefits. This is really easy for them to do also with people with chronic fatigue syndrome and long COVID, because so much of the symptoms overlap. So it's something to really be mindful of. And if you happen to, if you hit that roadblock in a claim, definitely something to talk to an attorney about. But the thing I'll say
That's a good
quickly is
point.
that don't be afraid to have your mental health provider contribute as far as saying, yeah, this person is treating me for mental health issues, but they're not impaired from their mental health issues. They're impaired from their physical conditions. Most people just kind of want to shield their mental health providers because they just don't want them involved in the claim. But having them identify that your issues are physical, or at least not mental health related, is often one of the biggest steps we take when we're handling a case like that.
That's a great point.
I would add one thing. Um, if you are disabled and you're going to make a claim, you don't need to rush out and hire a lawyer. There are billions of dollars paid in disability claims. They're not all denied. We see the percentage that are not denied. But let me tell you when to hire a lawyer and how to hire a lawyer. The when is if they deny your claim and tell you you have an appeal right under ERISA. Because
Yep.
if you don't do it right, you're gonna lose, and don't be penny wise and pound foolish. How to hire a lawyer? Well, referrals are good, but from our perspective, the most important thing is to make sure you are finding lawyers that are going to trial and winning, because they're the lawyers. They're going to fight the hardest for you. If you go to a lawyer and ask them, "Can you give me a list of your wins?" and they say, "Well, I haven't actually gone to trial in 10 years." That's not the lawyer you want, because the insurance companies will know this lawyer doesn't take cases all the way. We can basically coerce him into taking a small settlement. So you want to make sure that any lawyer you hire has a good reputation and is a fighter.
That is an excellent point. Thank you so much. And for everyone, you can go to kantorlaw.net, KANTORLAW.net. You have several offices along the West Coast, many attorneys. Do you only do California cases, or do you consult with people out of state or nearby states, or is it just California for you guys?
We have lawyers in a number of states, but things have evolved. We can handle cases in any state in the union.
Wow,
And if we can't,
amazing.
we can help you find someone who
Yes.
can.
You are my type of hero. You are the ones that are out there. Just, I mean, I don't know what we would all do without attorneys like you. Thank you so much for your work and all that you've done. And thank you for coming on and explaining all of this. I so appreciate it. And for everyone else, we'll see you next week.
Thank you for having us. Have a good one.